Hello, everyone, and welcome to Thursdays Live with Chug. Each week, we cover pressing topics that matter to you and your business. I'm Ariana Gonzalez with Chug Attorneys and CPAs, tuning in from our San Diego office. And joining me today is partner and attorney Angelita Chavez from our Kennewick, Washington office. Hi there, Angelita, and welcome.
Hi, Ariana. Thank you for having me.
Thank you so much for being here. Today's topic is, should you hire foreign workers? We're going to be covering the pros and cons of hiring foreign workers. Just a quick disclaimer before we begin, we are live on YouTube, LinkedIn, and Facebook, and this conversation is for informational purposes only. It does not create an attorney-client relationship, so please comment your questions below or email us anytime at info@chug.com so we can help you out. So let's start with the basics of immigration. Angelita, can you talk to us about what the general process is for employers to legally hire foreign workers in the United States?
Thank you for that question. So, in general, the hiring process for any employer who wants to hire somebody, whether they are a U.S. worker or a foreign worker, is to ensure or to request that employment authorization. Right, anybody who wants to work in the United States that are physically present in the U.S., they have to have an employment authorization. So this could mean that they are authorized to work because of the type of visa that they have, or because they acquired employment authorization through another status. For example, those with pending asylum applications, those folks would be able to apply for employment authorization and therefore be lawfully authorized to work. On the other hand, we have also folks with deferred action status that can also have employment authorization. And there's many statuses that allow that person to apply for employment authorization and to be lawfully authorized to work. Other folks that could be authorized to work are folks that are in the U.S. on H-1B visas or L-1 visas, and those visas don't require separate employment authorization because they're already authorized to work by the fact that they have that H-1B or L-1 approval. Employers, when they're hiring, whether it's a foreign worker or U.S. worker, also have to make sure that they are, properly completing their Form I-9s, right? That's the employer's responsibility to be able to do that, and HR should also know how to properly complete those forms so that they can have those workers be able to get onboarded and work with them. One quick note that I wanted to bring up, especially with hiring and that Form I-9, is that sometimes employers that have the system of E-Verify think that E-Verify is sufficient and they don't have to do Form I-9. This is actually incorrect. The E-Verify system does not replace the legal obligations and requirements for any U.S. employer hiring any worker, U.S. worker or foreign worker, regardless, from actually being able to properly complete and retain that Form I-9. So always be completing those forms as required by law and retain those forms as required by law if you are a U.S. employer.
That's really helpful to know how important those forms are. I appreciate you covering the importance of that. So let's say an employer does want to sponsor an employee and hire a foreign worker. How would this employer go about sponsoring this employee? Can you talk about that process a little bit?
Sure. Yeah, thank you for that question. I mean, it's really going to depend on what type of position you have for this foreign worker, whether they already are in the United States on a different visa or in a visa status or in a lawful visa status. Maybe they are that potential employee is with another employer on an H-1. Maybe they want to transfer to you. And therefore, you would have to file that petition with immigration, file that transfer, and have that employee start. On the other hand, you might have already workers potentially in a parent company abroad. Let's say you're in a U.S. employer with subsidiaries all over the world. You might have some employees there with specialized or advanced knowledge that you want to transfer to the United States, as L-1Bs, or you have some managers that you want to transfer on L-1As. So all of those types of petitions as an employer require you to file something with the United States Citizenship and Immigration Services. Usually it's a Form I-29, along with other requirements. For H-1s, you might be required to also have to file an LCA before you even file that petition. So all of that gets filed with immigration. If that is approved, your employee is abroad, they would be able to use that approval to apply for a visa and enter the United States, and then they can properly start working, upon entry or upon whatever validity dates, right, are on their approval. So those are the general processes, but in reality, it's going to really depend on the type of employment you have available for that worker, whether they are already in the United States in some sort of lawful visa status that allows them to change to an H-1, for example. or transfer them to another visa status. For those employers that maybe have never hired a U.S. worker, they have some candidates and they want to bring them in on H-1Bs. That employer will first have to enter those workers onto the lottery for the CAP lottery that happens every single March. And if your workers are selected at that point, then you're able to start filing those petitions in April, but they would not be able to start working until October 1st. So it's a bit of a process and it really depends. Now, there are other visas that you may not have to enter the lottery for. Perhaps you have an E3 employee from Australia, or you have potentially a TN worker from either Canada or Mexico. You might be able to bring that worker in. But again, most of those do require filing some sort of petition with immigration, getting that approved, and that employee being able to successfully enter the United States on that valid visa status. So there's just so much more to the process, and that's why having an attorney, somebody who's really experienced to walk you through whether your employee has the right qualifications, the right credentials, and whether that type of job that you have available for them is something that fits also that type of visa.
That's great information. It sounds like there are so many different options for all the different types of visas. So definitely check with your immigration professionals. Reach out if you want to know about all the different types of visas. We could, make a whole video on that, and I think we might have one on here. So let's talk about the benefits of hiring foreign workers. So how can hiring foreign workers, in your perspective, contribute to the diversity and inclusivity of a company?
Yeah, that's a great question. Sometimes we think about potentially the economical benefits of hiring a foreign worker or how it can contribute to your business, but there's also so many more even intangible type of benefits in hiring foreign workers. Foreign workers really can help promote cultural exchange within the workplace. They can enrich your workplace because of the diversity and the different kinds of countries where these workers might be coming from. They also, can come with like these different global perspectives because they've had different experiences. They've worked with other businesses across the world, perhaps, and they're coming in, and that could really potentially be very valuable to your business or your operations.
That's really helpful to know. Definitely, they bring, a whole different world of skills from where they're coming from, a different perspective, a fresh mind. So it's definitely so many benefits in that. So in what ways can foreign workers help companies fill these skill gaps that they have or shortages in specific fields that they might have?
Sure. So, the industry, many different industries can potentially have skills gaps or shortage gaps, depending on what's going on with the economy or whether folks are graduating right under with certain degrees. So that could all pose a problem for those employers who are really trying to fill that gap. So these foreign workers oftentimes have specialized skills that are really scarce within, the domestic workforce. And again, for many reasons, right? So this could be very helpful for employers in filling that critical gap. They also, can bring in, innovation and innovative ideas, creativity, and as well as they can provide access to maybe, give you a competitive advantage, right? Because sometimes these workers will have these innovative ideas. They can drive more technological development or product development, just different things that we might not really see just because of whatever workforce we have in the area. So these workers really kind of help infuse that and really inject a lot of that in there. And oftentimes too, hiring foreign workers also creates opportunities to even hire more workers, right? And open your business and increase it, so that way you even also contribute even more to the local economy. So there's really some of that give and take there too.
That's a great point. It just opens up a new door for expansion in so many different areas and bringing in more talent, more international talent. So I know you've worked with many companies going through this process on both sides. So could you talk about what you've seen the best practices might be for addressing cultural sensitivity in a diverse workplace? They're often coming to a different country. How do we address these difficulties?
Yeah, so as we do know, having a diverse workforce can be very beneficial, right, for different kinds of employers and workplaces, and as people become more aware of the importance of diversity, that really comes home when it comes to hiring foreign workers, especially because they are going to be coming from different places, different countries, different backgrounds, different cultural norms. So no, first of all, creating a safe work environment is very important because we are required under federal and state law, right? We have federal and state laws that require having safe work environments. So if you don't have a safe work environment for different types of perspectives and cultures to be able to just be able to work together, that could be an issue under both federal and state laws. So making sure that we're abiding by those laws, having those safe work environments, avoiding discrimination. We are not, as employers in the U.S., cannot discriminate against foreign workers or U.S. workers, right, and vice versa. So both U.S. workers and foreign workers have to be treated the same. And also you can't discriminate against race or national origin, which most of these workers obviously are of different national origins because they're coming from different countries. So not minimizing those sorts of things is very important, making sure that that's not happening, because again, both federal and state laws will generally have some sorts of protection. So having workplace trainings that can minimize bias, discrimination, those sorts of things are quite important, because again, hiring these potentially foreign workers, it really facilitates a lot of cultural exchange in the workplace. They can really enrich the working environment of people. I mean, we know in our firm we have employees from all over different parts of the world, speak all sorts of different languages, and it really does create a very enriching type of workplace environment, where you get to learn about things that you had no idea, or different cultural celebrations you didn't know about, and it makes coming to work a great place. So celebrating those cultural differences can also help create that inclusive workplace.
Those are great insights. And yes, personally, from firsthand experience, it's such a beautiful environment to be in, and learning about all the different cultures and celebrating with everyone. And it's definitely a beautiful thing. So let's talk about the challenges of hiring foreign workers. So what are some common legal challenges that employers might face when they're in this process of trying to hire foreign workers? Do you have some insight on that?
Sure, yeah. So just as there are obviously lots of benefits to being able to hire a foreign worker and getting that all of those benefits from having those types of workers, and including the different ideas and technologies and skills that they might have, there are definitely a lot of obligations that could come with some challenges for employers that they should understand before undertaking such a thing, such a sponsorship, because it does come with those responsibilities. So employers who are hiring, foreign workers, they have to comply with both federal immigration laws as well as even state employment-based laws. These can be very complex. They can sometimes change, from one moment to the next. As we know in this industry, things are constantly changing. So having systems that provide best practices and mitigating some of those risks is really important. Making sure that you're in compliance with a lot of those things is important. Again, being aware of how to properly fill out your forms, just some of those basic things, but I can go into a bit more details.
That's so helpful to know, to cover those challenges that they might come across when going through this process. So when you're comparing hiring domestic hires, how might the hiring process for foreign workers differ in terms of time and resources compared to hiring domestically?
Sure. Well, in terms of resources, most employers are liable for the petitions, right? To make sure when they're sponsoring that worker, they'll have to cover a lot of those fees for that worker. So there, in terms of that could be a little bit more expensive. But in terms of actual hiring practices of onboarding that employee, it has to be the same as a U.S. worker, right? Again, you cannot discriminate. You cannot treat foreign workers differently than U.S. workers, or vice versa, or prefer foreign workers over U.S. workers. Those are all would be prohibited by law. So in terms of onboarding and those sorts of things, that would be the same. Yeah.
That's helpful to know. So make sure that the onboarding process is the same. There's really no difference once you hire somebody in terms of foreign or domestic.
Mhm.
So let's talk about legal responsibilities when hiring foreign workers. What are the key responsibilities employers have towards their foreign workers in terms of visa and sponsorship?
Yeah, so I touched upon it just a little bit earlier in terms of when you're sponsoring a foreign worker, let's say an H-1, for example, you as an employer would have to, cover those petitions, that petition cost. You cannot put that on, the employee would not be able to pay for that directly. And in addition to that, you would also be liable for paying the prevailing wage. So I can go over a little bit of some of those lists. So first and foremost, again, complying with immigration, right? You would have to be aware of immigration law and policy, be able to comply to that. For somebody who is coming to the United States as an H-1B worker, you would have to first file that labor certification application with the Department of Labor, that LCA. And so you would have to comply with all those terms and conditions on that LCA, including maintaining a public access file that would be necessary for people who want to inspect it or are available for audits, for example, as well as workplace postings and notifying other U.S. workers that you're hiring that worker, knowing when that employee can actually start and making sure that that employee does not start earlier than what they would be authorized to do, as well as ensuring that that they're also not working beyond their authorized stay, or that they're properly extending their authorization before their authorized stay in the United States, especially in the case of visas like H-1s or Ls and things like that. Other obligations involve notifying immigration of any changes. Let's say your worker is an H-1B worker, and let's say now that they are going to be moving to a different location or a different position that is really a material change to the current terms and conditions of that employee's job. In that case, you are obligated as an employer to notify the United States Citizenship and Immigration Services in advance of those changes, so you can properly file what's called an amendment with the USCIS. And once that amendment is filed and start dates are proper, that person would be able to start that change, but not before. So those would all be terms, as well as, again, paying that prevailing wage, right? So whatever prevailing wage you would have to pay that H-1B employee, you cannot pay them less than that prevailing wage. And again, it's to protect both, U.S. and foreign workers. If your employee is, of course, if you terminate your employee because that job is no longer available for whatever reason, you still have to maintain your PAF for at least a year. And you also should notify the United States Citizenship and Immigration Services that that job is no longer available, that person's no longer with you, and you would offer that employee reasonable cost of return home. So there are really a lot of responsibilities that could be involved in that sponsorship, which is why it's so important to partner with an experienced immigration firm, immigration lawyers who can really walk that employer through all of the compliance matters, so that they are complying with both, with federal immigration law and ensuring, that they're doing everything that they can on their end in terms of obligations to not jeopardize, their employees.
Yes, that's great information. It's definitely important to check with our immigration professionals, make sure we're following all of the responsibilities, doing everything the right way. And speaking of that topic, I know we covered a little bit about how we do have to treat our U.S. employees and our foreign workers the same in terms of treatment and pay, and there are standards that need to be met when hiring these foreign workers. So going a little bit deeper into that, are there any ethical considerations that employers need to bear in mind when hiring foreign workers, especially in terms of equal pay and fair treatment? Is there anything additional that you can offer some insight on?
Yeah, sure, thank you. Yeah, so in terms of ethical considerations, I would also consider them both ethical and legal considerations, right? Because again, those anti-discrimination statutes, not being able to not being permitted, right, to discriminate with both U.S. and foreign workers, again, treating folks equally in terms of employment conditions, etc., and also complying again with that prevailing wage, super important. Things do change, obviously, in the industry. Sometimes, a company might be going through hard times, etc. That does not eliminate those wage obligations if you have a foreign worker. So keeping in mind that these obligations remain right throughout that person's employment that you have with you, and the conditions on that petition that you hired them for. So just kind of keeping those things in mind is going to be super important to know really what you need to do as an employer when hiring foreign workers.
So this video is about pros and cons of this process. So let's talk about some potential risks that we might get into. So we talked about all of the benefits of hiring foreign workers. So are there any risks associated with relying heavily on a foreign workforce in terms of legal challenges or immigration policy shifts? I know we talked about things in immigration are always changing, so we definitely need to look out for that. So what insight can you give us on this?
Yeah, there can be some issues for sure, heavily relying on a foreign workforce. So let's say, for example, going back to the H's because they seem to have a lot of rules and regulations around them. Going back to the H's, if you are a dependent employer, an employer who has 25 more, or if you were equivalent U.S. employees and you have at least 8 H-1B workers, or you have between 26 and 50 full-time U.S. employees and at least 13 of those are H-1B workers, or if you have 51 or more employees and at least 15% of those are H-1B workers, you could be considered a H-1B dependent employer. And so those employers are going to have additional attestations about not displacing U.S. workers. They also have to potentially do active recruitment of U.S. workers. So there's going to be potentially some legal obligations involved with heavily relying. But you also mentioned potentially policy shifts, right? If you are really an employer that more heavily relies on foreign workers, when policies shift and change, that may not necessarily be very beneficial, and that could be an issue with having the workforce that you need on hand potentially, or the facility of bringing those workers to the United States, if you are more heavily relying. And again, laws exist so that doesn't occur, and employers again would have these attestations and obligations to actively be recruiting U.S. workers. And even in the perm process, which is a process of hiring a foreign worker permanently as sponsoring them for a lawful permanent resident status, those preference-based categories usually, they do have to go through the perm process, which requires actively recruiting U.S. workers before you can even offer that foreign worker that permanent position, right? So again, it's to protect those U.S. workers, and that's always going to be at the foreground of everything.
That's great to know that those laws are in place to also protect the U.S. workers, as well as offer opportunities to foreign workers as well. So it definitely seems like there's greater benefit in diversifying the workforce, having U.S. workers, and then also bringing in the skill and fresh minds of international potential foreign employees. So we do have an audience question. I do think we have some time for this. So what happens if a foreign worker's visa is not renewed or denied? How does the company handle this issue? Do you have some insight we can cover on that?
Yeah, thank you for that question. So important. Oftentimes we don't want to think that a bad thing can happen, right? We want to think the best, and that employee is going to have their approval, everything's going to be fine. But there are going to be situations in which someone might have a denial for whatever reason. So first and foremost, having an immigration firm, an immigration attorney who's really experienced in the area, that can navigate the different options available. It's all really going to be contextual. If that petition was denied for just maybe something was missing or whatever, it could be possible that they could apply again. If that person's authorized, if they're in the United States but their authorized stay has expired and their petition has been denied, they definitely have to depart immediately. There are going to be severe consequences of overstaying in the United States past your period of authorized stay. So that employee whose H1 or whatever the case may be was denied, they'll have to obviously leave the United States so that they don't accumulate that unlawful presence and cause them immigration consequences in the future. But potentially that employer could reapply for them, make sure that everything's complete, nothing's missing, and that they might be able to come back on that same type of visa. It's really going to be very contextual. Oftentimes it's possible to reapply, or maybe file a motion to reopen or an appeal of some kind on that denial, and sometimes that's enough. But it's really going to be talking to your immigration attorney so that they can really take a look at your situation, find out what happened, and help you find the right route to be able to address that issue, whether it's reapplying or appealing that decision, and having that person be able to come back after they depart. So it's going to be very contextual.
Thank you for going into detail and covering that. That's definitely important to know. What happens, when it doesn't work out, or when it's not renewed or denied, what are the next steps? What can we do? And definitely speak with your immigration professionals. Make sure you're taking all the necessary steps and handling things properly so that nobody gets in trouble in the process. So thank you so much, Angelita, for taking the time to discuss this and share your insights with us. I know you're super busy, so thank you for taking the time, and thank you everyone for joining us today. That is all we have time for, so that does bring us to the end of our conversation. Thank you again for joining us, and to stay up to date, please subscribe and follow us on YouTube, LinkedIn, and Facebook. And if this video was helpful, please make sure to give it a like and share it. Please reach out to us if you have any questions or suggestions. Email us anytime at info@chub.com so we can help you out. And make sure you join us back here next week for more pressing topics that truly matter to you and your business. Until next time, stay safe and take care. Thank you, everyone.